Well, let's begin here with chapter 1. We got a lot to cover. We'll do a introduction. We'll cover the sources of law. We're going to cover the difference between civil and criminal cases. We're also going to talk about crime and the crime classifications and the purpose of punishment. That will be what this video is about. The next video for this week, we'll discuss the sources of law. So without further ado, we'll jump right in. And just to give you free warning, there is no stop and start. What you're going to get is what you would get if we were standing in a classroom and I was speaking on this topic, preferably asking you guys these questions. So there, you might hear a dog bark, you might hear a siren. I live in the city, so I don't know what's to come, but hopefully we can work through this time that we're in, and we're going to be online this semester. So criminal law. You need a law. What is law? Normally I'd ask you guys to give me what you thought law was, but since I can't do that, this is going to be the general definition of law that we'll use for this class. Rules that attempt to guide human conduct and a set of governmental sanctions that are applied when rules are violated. But what is crime? Actually, crime. Because laws can apply in an entire arena of things, but it might not make it a crime. So what is a crime? Well, it is an act that's committed in violation of a law that's prohibiting that conduct, or you're omitted from doing that conduct, but you do it anyway. So it's an act committed in violation of a law prohibiting it, or omitted in violation of a law ordering it. And we're going to learn specifically in next week's lesson what constitutes an act and what constitutes an admission to act. But right now, let's just work with this crime definition. Crime is an act committed in violation of a law prohibiting it, or admitted in violation of a law ordering it. But how do we get these crimes? These laws, these crime laws, how do we get those? They don't just kind of poof, here they are. They are actually created. And when we talk about sources of law, I'll tell you exactly where they come from. But how are they created? By the government. They create them, they enact them. And if it's not created, then it's not a law. Cities can create laws or crimes involving laws involving crimes. The state, the federal government. Can you see some problems arising? Can you think of any problems arising here? If we have states making laws, well, each state has their own body of law, so each state decides what's illegal within their boundaries. And the feds will create laws that are relative to the entire country, and cities will create laws. They call them ordinances in some places. Here they call it ordinances. When I say here, I mean Plattsburgh, because that's where I am, and preferably if we were in a classroom, where we'd all be. So city of Plattsburgh, they have their own laws. They call them ordinances. And what might be legal in New York might be not legal someplace else. For instance, the example that pops out is possession of marijuana. In some states it's illegal, in other states it is not. Very recently, New York State no longer made it a crime and basically invalidated their crimes. The crime for small amounts of possession of marijuana, Colorado, it's legal. Vermont, it's legal. So what happens though? Can anyone, let's say you are coming from Vermont and you have a small amount of marijuana on you, and you go to a state that finds it illegal. Does it matter that you started in Vermont? Hey, it was legal in Vermont, so I was good to have it. No, if you get caught in a state where it's illegal, despite where you came from with it, it still would be considered a crime, and you could be arrested and possibly punished for that. There are states that still have, a lot of states have laws on the books that they don't enforce anymore. I'm going to read you off a couple here. The one primary one I like to talk about is the burning of the flag. There's 48 states that have some law on the books that's relative to the destruction of the flag. But I will tell you that it's probably not enforceable. Why might it not be enforceable? Because the Supreme Court has ruled that in a number of instances, burning the flag is a freedom of speech. So while there might be laws that are still on the books that haven't been invalidated by the legislators, they will have no enforcement. And some fun ones, and I'm going to ask you to do this in one of the assignments, is to see if you can find a law that still seems to be on the books but inapplicable. But here's 3 from New York. It's illegal in New York State to transport an ice cream cone in one's pocket on a Sunday. In Sag Harbor, New York, it is illegal to disrobe in a car, so you can't get undressed in the car. It is illegal in New York City to have a puppet show in your window. And for whatever reason that those laws were created, they no longer seem to be applicable now. So they can change. They're not static. They don't stay that way. Some more serious things that have changed, at least in New York, and you've probably heard about it, read about it, saw it on social media, is there was a recent change in our bail laws in New York, making it a little harder for a court to set bail on folks who are arrested for crimes. The discovery laws. Discovery is something that the prosecutor has to turn over to the defense attorney. We'll talk more about that later on the semester. And about a year ago, New York raised the age. You could be arrested in New York for a crime if you were 16, 17, 18 years old, and you'd be tried in adult court. New York has made changes to that, and you would be, if you were between the ages of 16 and your 19th birthday now, your case will be heard in a youth court, they call it. They don't call it juvenile court because that's still 13 to 15. But those are some examples of how laws change over time. Now let's talk about the difference between criminal law and criminal procedure. Some of you may have already taken the criminal procedure class. It's an entire semester you can learn about criminal procedure. It is different than criminal law. We may make touches on it to explain differences as we go along in different laws as we move ahead, but this is something that we're not going to really cover. So hopefully you've taken criminal procedure, or it's on your agenda to take criminal procedure. But what's the difference in these two? Well, criminal law is defining the rights and obligations of individuals in society, how we must behave. Don't do A because you can be punished for doing A. That sort of thing. It directs us as individuals on how to behave in society. Procedure, it deals with enforcement of one's individual rights during the criminal process. So you're already in the criminal process. You have already violated allegedly, let's use that word, allegedly violated some law, and now you're in the criminal process. And this is the criminal procedure determines how those rights are enforced. And this is geared to, did the government act properly? So we're dealing with the law enforcement, basically. How was the arrest? How was the charge? Were you arraigned? Did they try and take a statement from you? Or interrogate you is a fancy word. Did they take something from your possession that may or may not be proper? A legal search and seizure. May have heard that term before. That's what criminal procedure deals with. It focuses on our law enforcement and if they did things properly. So how do we know which one that we're dealing with? You're going to want to ask, for criminal law, you're going to ask, did the defendant commit a crime? Which crime did the defendant commit? Does the defendant have a defense? These are the 3 things you're going to ask for when we're dealing with criminal law. And as we move forward, you're going to learn the types of defenses. You're going to learn about specific crimes. You're going to have to look at a certain scenario and determine whether a crime was committed. So those are the 3 questions you're going to be asking yourself throughout this course as we move forward and learn the specific crimes. Now with criminal procedure, a question you won't be asking yourself, but to know the difference, is did the government act legally in any of these areas during their investigation? This is where the illegal search and seizure can come up. This is where Miranda warnings, you weren't read your rights, the right to remain silent, right to counsel, those things that you hear from TV all the time and cop shows. During the arrest portion, do they take you before a judge? You have a right to appear before a judge and be told what you're being charged with. And overall, in the prosecution of the defendant. So those things tie with criminal procedure. Let's look at a couple examples. So you and your friend are in the mall. Your friend steals a CD, and you say nothing, even though a security guard is right there and available. And the question is, was there a crime, or is this criminal procedure? And I hope you're saying in your head, poof, that's a crime. Somebody took something, right? What's going on here? Friend stole a CD. Can you get in trouble? Probably not, but that's a question for criminal law. Did you commit the crime? And I'm going to say probably not. Now we have you and your friend are both arrested, and your friend is placed in a room in a police station for 4 hours alone. The officer returns and starts asking him or her questions about the theft. After 3 questions, your friend says he wants a lawyer, but the cop says you don't need a lawyer, and continues to question the friend about the theft. Do we have a criminal law issue, or do we have a criminal procedure issue? We have a criminal procedure issue. Is the cop acting within the bounds of this individual's rights? So that's a criminal procedure issue. That's the key distinction between these two. We're going to be focusing on criminal law. So you got to remember those 3 questions you're going to ask yourself is, did the defendant commit a crime? Which crime did the defendant commit? And does the defendant have a defense? We're going to be thinking about that as we move through the semester. How about we do one more? The police detain you and lock up for 30 days before you get before the court, because now you've been charged too, but you might have a defense. But do we have a criminal law issue or a criminal procedure issue? We have a criminal procedure issue because you're entitled to go immediately before a court and be told what you are charged with and what your rights are. So this is a criminal procedure issue. So what's the difference between civil and criminal cases? Because we have 2 types of cases that we deal with in the judicial system. Our civil lawsuits, we have our 2 parties are called a plaintiff and a defendant. The plaintiff is the one that brings the lawsuit, and the defendant is the one that's being sued. And this is just an overview, so we can pull out the distinctions between civil lawsuits and criminal cases, because we are going to be focused on criminal cases, and I don't want there to be any confusion. So what happens in a civil case is a plaintiff will pick a court that can hear a case, and they file a piece of paper. It's called a complaint. Sometimes it's called a pleading. We'll stick with complaint. And it really states why I'm bringing this case against the other person. Now let's talk about an actual civil case so we can put it in context. Let's say there was an agreement between the plaintiff and the defendant. The defendant agreed to paint the plaintiff's house per the plaintiff's instructions, and the plaintiff agreed to pay the defendant $50,000. Okay? So let's say the defendant started painting the house and then stopped showing up. And the plaintiff's mad because the plaintiff wants the rest of their house painted. And the defendant might say, well, I want half my money that I did for already painting. So the plaintiff will start their case they'll pick a court. They'll say, I'm suing for breach of a contract, and I want to be reimbursed, or I want him to finish. They'll be asked for something, but most of the time they want a return of money. And the only person who can bring a case in a civil case is the person who has been damaged or suffered the harm. So let's say you are the plaintiff and your mom lives in your house with you. That agreement is between you and, let's say me, I'm the defendant who was supposed to paint your house. That agreement is between you and I. If your mom is mad about the fact that I didn't finish painting the house, she can't be the one to bring the lawsuit. It has to be you, because you made the deal. You're the one with the stake in the game. So the defendant gets served with a complaint. They're allowed a time to respond. No, I didn't do that. Oh, he's got it all wrong. Oh, he told me to stop painting the house. That sort of thing. They get to respond. The court will hold some sort of settlement conference. If it can't settle, there will be a trial, and it is up to the plaintiff to prove their case against the defendant. And this is an important concept right here, the burden. That burden of proof, it's got a fancy legal term. It's called preponderance of the evidence, meaning more likely than not. Think of it that way. And if you can visualize me holding up my hands like I'm doing a scale, they're kind of equal right now, but if you just tip just a tad bit higher for one, that's the proof. And that's a key point because it's extremely different than in a criminal case. So it's a tad bit higher. And then if the defendant comes in and says their piece, that's not how it went down, they can tip the scale back the other way, but a little bit higher in their favor. So if the scale is higher in the plaintiff's favor, the defendant is going to be found liable or at fault and will have to do whatever the judge says, pay the plaintiff for damages or finish painting the house. If the defendant wins, maybe his claim is they told me to stop doing it, and that's the side that wins, then nothing. It's all over. But the key between civil cases, with a civil case, is our plaintiff and our defendant are individual people. Could be you and your neighbor, could be me and my neighbor. They're individuals who are dealing with something. I don't want to say fighting over something, but they're dealing with something. So that was the basic civil case. Now I remember I had pointed out the burden of proof, preponderance of the evidence. Another key distinction before I move into criminal prosecution is the jury. You don't always have a jury in a civil case. And as a matter of fact, that is not a right somebody has. They have to ask for it, and they actually sometimes have to pay for that service. But if there is a jury involved and they make a decision, their decision merely needs to be a majority of the panel. And that's a key point I want to make before we move into criminal prosecution, which we are going to talk about right now. So as I said, with a civil case, the parties involved are individuals. With a criminal prosecution, the case is always brought by the government. It's law enforcement who makes an arrest. It's the prosecutor or the people, as they're sometimes referred to. If it's a United States case, federal case, they're referred to as the government. It's always a government entity against an individual. Okay? So, you're arrested, or somebody's arrested. What happens? How do you know you have a charge? The police come and get you, right? Or you might be just served with a piece of paper that says, go to court on a specific date. But you get notice. That's how you get notice. The police are either going to come and get you, or they're going to come and hand you a piece of paper that says you've been charged with a crime, with a court date. You go to court, or you're brought to court, and you will go through a process that is called arraignment. And how do you know? Because you're in front of a judge with a black robe. And what happens at an arraignment? The judge will read you what you're charged with. You will say guilty or not guilty, or the defendant will say guilty or not guilty. If the individual says not guilty, and let me back up, there's one more little point. During that arraignment, you read your rights. Obviously, very important. You read your rights. The judge will tell you the same rights. The right to remain silent, the right to counsel, right to a jury trial, and a right to have counsel at every stage of the every stage of the case. And if an individual right then and there, and this happens before the court takes the person's plea, what happens if the individual says they want an attorney? Everything has to stop. Nowadays, I kind of glossed over it because nowadays in the state of New York, When somebody is going to be arraigned, there will always be an attorney present. It's a law that attorney must be in the courtroom when somebody is going to be arraigned to assist that individual in the arraignment, and that unless the individual already knows that they're going to go before a court because they were served with a piece of paper and have to show up and they've made arrangements for their own attorney to be there, the court will have appointed a counsel that is usually on call to appear. So that person will be there. So they will already have counsel there to assist in the arraignment process. But one of the rights is you have a right to an attorney at every stage of the game, including that arraignment. And then at that time, a plea will be entered. Plea guilty, plea not guilty. Now you might think, why would that? Some folks, especially on a low-level case, let's say back before New York made small amounts of pot possession legal, it was merely a violation. It was punishable by a fine, and most people would walk into court if they were charged with that and plead guilty. However, because based on the assumption is that, yeah, I had it, they found it, I'm guilty, and that's all nice and well and good. But in some instances, different arrangements can be made because there were certainly some repercussions, especially for young folks who were in school and getting federal financial aid. That could having something like that in your history could gum you up a little bit in school. Not a lot of people knew that for the longest time, but I'm kind of digressing here. I would have shared that story with you if you were in class in a little bit more detail, but sometimes it's not a good idea to plead guilty right away until you've had a full opportunity to speak with an attorney. But in other instances, it's very plausible to do so because you can't be tried for the same crime twice. And if the prosecutor's thinking about charging you with a higher level of the crime you're charged with, you might want to get in and out pretty quick and plead guilty and deal with what you're already having to deal with. But we'll talk about that as we go on. Well, right now we're just going to kind of go work through the criminal prosecution side of things. So let's say the person pleads not guilty. The judge will hold a pretrial conference, and because there is this criminal procedure component called speedy trial, you have a right to a speedy trial. The court will push this case right along, have a pretrial conference. If it does not settle, there will be a trial where a jury is mandatory. We have a constitutional right to have a jury trial versus our civil case, key component. And the government has to prove the charges against you. And I'm sure many of you have heard this terminology before. They say it all the time in crime shows, is beyond a reasonable doubt. So if I'm holding up my scale again, visualize me holding up my scale again. I got my hands even, two sides of me up. That has to drop one side way down low and the other side way up high. Now that doesn't mean no doubt whatsoever. It just means a reasonable doubt that, beyond a reasonable doubt, that the defendant committed the crime. And that's a big burden. The defendant does not have to do anything. Does not have to say, but I'm innocent and here's my side of things. Can they? Sure. But they're not required. And the fact that they don't do that can't be used against them. Why? Because they have the right to remain silent. And if a jury makes a decision, that decision has to be unanimous. It can't be a majority like in a civil case. And this, I'm going to point out, was not always the case. There were two states in the country, Oregon and Louisiana, that both said a majority jury was fine in criminal prosecution. And that was challenged all the way up to the United States Supreme Court as unconstitutional under our 8th Amendment. And back in late March, early April this year, during the beginning stages of the coronavirus, the court ruled that it was unconstitutional to have a non-unanimous jury verdict. So the law is jury verdict must be unanimous. Now, if the person is found guilty, the judge is the one that has the job of giving them the punishment, not the jury, not the prosecutor. While the prosecutor has a say with what they might want to see happen to the defendant, and the defendant has a say what they want to have happen to them, the judge is the one that imposes the sentence or the punishment, and that is going to be based on what the crime is. And we'll talk a little bit more about that as the semester goes on, about specific punishments. So what's the goal of a criminal prosecution? I think it's twofold. You want to punish the defendant for his or her conduct, but you also want to deter society from engaging in the conduct. So it's kind of twofold that you're involved in here with the criminal prosecution, because that's why the government is the one that does the prosecuting. It's their job to protect society and make sure society's laws are followed. Now, next week we'll talk more about intent and so forth, the mind that you have to have relative to the specific crimes, or the mental state you have to have. But you always have to have some fault, right? There always has to be that's always going to be some component of a crime, that the defendant intended to do what they were doing, or they were knowingly doing what they were doing, or they were recklessly doing what they were doing, or they were willfully doing what they're doing. So there's always going to be a fault component in criminal cases. In civil cases, fault really doesn't come into play. You might, in our breach of contract case, somebody messed up. Nobody intended to, I intend to do that. Somewhere along the line, somebody wasn't happy and something doesn't go right. It's rare that in a civil case, somebody's doing something intentionally to the other side. Do you always have an injured victim? In an assault case, that's pretty obvious, right? If you punch somebody in the nose and break their nose intentionally, and we'll say it's not in self-defense, you have an injured victim. You have a face with a crime. Civil cases, you always have a face with a crime. You can't sue unless there is a harm. But in a crime, can we not have a victim? Sure. What about drug sales? Drug sales, drug possession, or guns. I know I'm stuck on the drugs there for a little bit. It's a good example. Quite frankly, we'll probably use a little bit more of those examples. I think they're easy to explain or show different points. But drug sales, counterfeit, making counterfeit money. You don't have a victim's face, right? It's illegal to possess a switchblade here or a taser in New York. Unless you use it on somebody, but then you have an assault. But if you just have it on you, is that still a crime? You don't have a victim. Yes, these are crimes against society, keeping society safe. That's the goal. I like the example in the book. Stephen is angry because his friend Bob broke his skateboard. Stephen gets his gun, which has a silencer on it, and puts it in the glove compartment of his car. He then begins driving to Bob's house. While Stephen is driving, he exceeds the speed limit on 3 different occasions. Stephen arrives at Bob's house, and then he hides in the bushes by the mailbox and waits. After an hour, Bob opens the front door and walks to the mailbox. Bob gets his mail, turns around, begins walking back to the house. Stephen shoots at Bob 3 different times but misses, and the bullets end up landing in the dirt. Bob does not notice the shots because of the silencer. Do we have a crime? We don't have an injured victim, but do we have a crime? Yeah, we got a lot of things happening here. Speeding, the fact in some states it might be illegal to have that gun concealed in a glove compartment. He's shooting at Bob. Maybe it's some other kind of crime. When Bob doesn't get hit, Bob doesn't know about it. So certainly these are crimes because we want to prevent Stephen from actually doing the crimes, but we also want to send a message to individuals in society that these things won't be tolerated. So yes, you can have a crime when you don't have a injured victim. Before we switch to crime classifications, I just want to make one point regarding distinguishing a case name, a criminal case name from a civil case name. If you were looking up cases, which is something we will get into this semester, is having you look for a specific case, is in a criminal case, the key distinction when you're looking at the title of the case name, you are going to see a government entity. You're going to either see New York versus Smith, U.S. versus Jones, or you might see the state of California versus Marks. It's going to have a government entity. City of Plattsburgh versus Box. If you see a government entity in the title, that's going to be your flag that is going to be a criminal case. Civil cases have people's last names. Box versus Smith, Smith versus Jones. That's how you're going to distinguish between the two. So let's talk about crime classifications. We have a couple Latin terms that are there in the book, malum in se and malum prohibitum. We don't actually use those terms in the working criminal justice system. I've never used them as a defense attorney or prosecutor, but the distinction is the malum in se. You have to have some real intent, and the statute will tell you what it is. Malum prohibitum, you're still committed a crime, but there's no proof of intent needed. You just need some sort of act that you've done voluntarily, and we'll talk the difference between act and mens rea coming up. And those two concepts are going to define the elements affecting the crime grades that we're going to talk about in a minute. Malum in se, unlawful means unlawful conduct that is evil in and of itself. And the first crime that pops in your head that might suggest that, murder, right? Malum prohibitum, you just need an unlawful act only by virtue of some statute. It's a crime to not pay taxes. It doesn't have to say where you intend to not pay taxes. If you don't pay taxes, whether you do it intentionally or not, the act of not paying taxes is a crime. So that's the distinction between those two terms. We're going to actually go through specific mental states that we're going to use that are in statutes, regularly in statutes across the various state crimes. Our crimes are listed as categories. Categories. You will find crimes affecting people. Assault is a personal crime. You will see categories, and we're going to break these. These are coming towards the end of the semester, and we actually go through specific crimes. We're going to talk about the crimes against people, the crime against property, crimes against society or government. An example of a crime against property, trespassing. And you go on somebody else's property. Criminal mischief crimes, crimes where you're destroying other people's property. That's property crime, even though there's a kind of a person involved. Another example of a crime against a person is rape. The victim is the person. Crimes against society. These are victimless crimes that we just talked about. Drug sales, drug possession, counterfeiting, things in that nature, weapon possessions, things like that. And our crimes are graded. And it seems to be, this is consistent grading across the country and the federal government uses. We have felonies, we have misdemeanors, and we have something called infractions. In New York, we call them violations, but the terms are interchangeable. And the felonies are the most serious. You may already be aware of that. And they can be graded in and of themselves. In New York, for instance, our felonies are listed A through E. A is the highest level felony. An example of that would be murder, is an A, class A, as they would say. And stealing something of value of $1,000 or more is a class E. We call that grand larceny, and that's a class E felony. So there's ranges, and what comes along with those ranges are the harshness of the punishment that will follow. Misdemeanors are the second level. Crimes are the middle level, we'll call them the middle level crimes. Things like we call something to you, if I used grand larceny before, I'll talk about petty larceny now. That might be the example of your friend and you in the mall, and your friend steals a CD. It's worth less than $1,000. It's going to be petty larceny. You steal candy from a store, it's going to be a petty larceny. It's going to be a misdemeanor offense. And there are all sorts of ranges of different kinds of crimes, but the highest penalty you can get for a misdemeanor is a year in a local jail. And of course, there's a bunch of, we'll talk about punishments, but there's a whole bunch of other punishments that you can serve. Our felonies could land somebody in prison. Harsher penalty. And then we have our infractions, which is the least of the least. Noise violation, speeding ticket, traffic, they call them infractions, traffic violations, things of that nature. They are minor. The pot possession, when it was illegal in New York, was an infraction, usually punishable by merely a fine. I will note that the book has something called felony/misdemeanor, not something we recognize here in New York. But I do want to point out that the government is the prosecutor. It's not either or. I think the distinction was they were saying that the government can prosecute a crime one way or the other. I think the suggestion is what you need to know is the prosecutor's job to decide what crime will be prosecuted against somebody, whether or not they can decide, well, we're not going to prosecute this case. They could totally say that. That's they're in control. If somebody's charged with, let's say, a assault that is a low-level assault, let's say punch somebody in the face, they got a black eye, and they're charged with a misdemeanor. Assault third is a misdemeanor in New York, where you physically injure somebody. The next level up is an assault in the second degree, where you seriously injure somebody. The distinction, and we're going to talk about assault later on in this distinction, but you got physical injury and then serious physical injury, and the prosecutor is the one that would have to prove the difference between the two. But they're also the one that gets to decide whether they're going to prosecute this as that serious physical injury, higher level, the felony, or the misdemeanor of the physical injury. So it's up to the prosecutor. So what's the difference between jail and prison? I alluded to that just a little moment ago when I was talking about felonies. Highest penalty could be prison time, misdemeanors, jail time. Cities and counties have local jails. In Plattsburgh, we just have a county jail. City of Plattsburgh does not have a jail. They have a holding cell, but they don't have like a jail where somebody would serve a sentence. They would serve it at the county jail. The feds in the states run the prison system. And the confinement restrictions, they'll differ. Prisons are obviously stricter. Jails are low levels. Example, Howard kills Mike, and he's prosecuted and sentenced to a year in jail. What grade of crime he commits, if it's a misdemeanor, which it's not, he will go to the local jail. If it's charged as a murder and he is convicted, he is going to go to a prison. Can you kill someone and get a misdemeanor? Highly unlikely, but we will talk about there when we get to homicide, chapter 9. We are going to talk about all the different types of how someone can be killed. I didn't tell you exactly how Howard killed Mike in that example, but in New York State there are 55 different statutes involving homicide. So you can see there's quite a range. So let's talk about what's the purpose of punishment. So we have our crime. Somebody commits a crime. They're found guilty of that crime after a unanimous jury verdict, and the judge has to impose a punishment. Why punish people for committing crimes? We already talked about it. It sends a message to society, don't do that. And it also punishes the person for doing what they did. And these are the 5 things that a court certainly looks at when imposing the punishment, but these are the purposes behind it, right? Deterrence, incapacitation, rehabilitation, retribution, and restitution. Let's kind of buzz through some of these here. Let's start with deterrence. Now, you guys may have already covered this in a criminology class, or actually this gets covered pretty good in Introduction to Criminal Justice as well. So hopefully this is just a refresher. It's just going to kind of be a recap, because what we are going to focus on is criminal law. But this is good to have a little refresher on. So deterrence. There's two types. I just said it. Specific and general. So what's specific? It involves the individual defendant. When an individual is punished, the hope is that they are less likely to commit another crime because of fear of a similar or worse sentence. Oh, I don't want to do that again. It cost me $2 if it's some sort of traffic violation. Also, let's take an example of DWI. We're all kind of familiar with DWI. Driving while intoxicated. The first time somebody does it, there are a lot of penalties that go along with it. Are they super severe? No. Can you go to jail? Sure, you can. Highly unlikely. It's very costly the first time around. And that might be a deterrence. Oh, God, it cost me like $5,000 to have to deal with this kind of case. But if the person does it again, the next charge elevates to a higher charge, which means there is a possibility of incarceration. I could talk about DWI until the cows come home, but the point is, you hope that the first time around, the person, it's a kind of a wake up. You certainly don't want to throw somebody on a, let's call it a DWI case, the first time somebody gets one, unless somebody's seriously injured. But we're just talking a standard driving home from a wedding, had a couple too many glasses of wine, and you get pulled over, and there's a process, and you're charged with DWI. That happens a lot, because you don't really know. We're not going to go into the details of DWI, but the reality is that is a real situation. And a lot of people that I've represented get it the first time. They're like, oh, God, I don't ever want to go through this again. And some folks it doesn't. But the point is, it affects the individual defendant, specific deterrence. And then we have the general, which applies to the entire public at large. They learn of the punishment, its severity, and then they fear criminal prosecution. You hope, I would think, that murder's deterred. You could spend your entire life being locked up in New York State. There's no death penalty here. But if you're in a state with a death penalty and it plays a role, the question has always been whether or not does the death penalty really deter murder, and that's certainly a discussion for a criminology class or an introduction to criminal justice. There are discussions on both sides of the coin. Most studies say no, but the question is, does the punishment prevent people from engaging in criminal conduct? And that's the hope. Incapacitation, that's another purpose of punishment, where you remove let's call it the problem or the defendant, from preventing further crime because you've removed them from society by incarcerating them. Another form of incarceration is house arrest. Electronic home monitoring is the fancy term, but removing them from society. Rehabilitation prevents future crime by altering the defendant's behavior. If we're dealing with somebody who has a drug problem or a mental health issue, treatment might be the better. Putting somebody in vocational training if they have like job or educational limited job, work history, or educational background. Counseling, this is rehabilitation is a perfect combination for something called probation, if you've heard that term when we say rehabilitation, where somebody's being monitored, but they are helping them with the behavior and altering, whether if they have a lack of education, they might have them I say a defendant, getting their GED, taking training courses, going to counseling, whatever needs to assist the defendant in altering their behavior so they don't commit crimes or the crime that they are on probation for or found guilty of. Retribution prevents future crime by removing the desire for personal avengement. Assault cases, right? Somebody punches you in the face and breaks your nose. If they don't get in trouble for it, you might want to seek some revenge. So retribution is another reason why we have another component of punishment is for that reason. The hope is that a victim or society discovers that there was an adequate punishment for this particular crime. So there's some sort of certain level of satisfaction. Restitution, payback. This is punishing the defendant financially. They might be required to pay a hefty fine. If we're dealing with a crime against a person, the victim is paid for their harm. Let's say it was the assault case and they were punched in the nose and they broke their nose. They have all these doctor's bills. The defendant is paying that bill. That's called restitution. Sounds a little like a civil case, doesn't it? You did this to me, you owe me money. And in fact, something like this could go to a civil case if it wasn't taken care of in a criminal prosecution. You could sue, but most of the time it will be handled. If it was related to a crime, it's going to be handled by the prosecutor in this case. And that's a fairly good move because you don't have the victim having to go and try and get their own money from the defendant. It's all taken care of in one area, but certainly the defendant or the victim is free to sue the defendant financially on their own. But restitution, payback, this is where the punishment is making the defendant pay back. So that is the first 4 questions that we started with for this week's lesson. The next video will cover the final question, which is our sources of law, so we can go through and work through the various sources of law.